Good evening. I'd like to call to order the City of Haslett's Planning and Zoning Commission meeting. Today's date is Tuesday, July 25th, 2023. The time is 6:30 p.m. and we do have a quorum present. Begin with agenda item 3, items of community interest. There are a number of employment opportunities in the city that are open right now. There's a city secretary position, a parks and ground maintenance worker 1 position. There's a part-time library assistant position. There's 2 different water maintenance workers. There's a position 1 and position 2, and then there's the audio, visual, and office systems and digital media technician opportunity. So if you have an interest in those, or if you know of somebody who is qualified for any of those positions, please tell them to visit the employment opportunities that you can find on the City of Haslett's website. Moving on, we'll go to our consent agenda. Agenda item 4A, discuss, consider, and act to approve our June 27th, 2023 regular meeting minutes. There's no discussion. Is there a motion?
Yeah, I'll make a motion that we approve the minutes as submitted.
Okay, is there a second?
I second it.
Motion seconded. All in favor? Motion passes unanimously. Moving on, agenda item 5A, hold a public hearing, discuss, consider, and act regarding an ordinance of the City of Haslett, Texas, amending ordinance 001-2021 Sweetgrass Plan Development by removing, including front yard maintenance of each home from the Homeowners Association required responsibility for maintenance. We're going to begin with our staff presentation.
Chairman Kadish and members of the commission, the maintenance of lots is not a city function and should not be part of a city function in the zoning ordinance. And it should be left to the homeowners and the HOA organization itself and not have the city as a third party. And so what this ordinance does, it takes that out of the ordinance where it says including the front yard maintenance of each home as part of the HOA duties. Now that doesn't mean that they cannot have that in their HOA bylaws, but it just shouldn't involve the city as a third party. And this is something that we recently did for the Caraway subdivision, and it was approved by the city council. I don't see one.
Okay. And at this time, we'll open the public hearing. So if there's anyone wishing to speak for or against agenda item 5A, you're welcome to come forward to the podium. If you do want to speak, please state your name and your address for the record, please. And is there anybody online, James? Okay. And recognizing no one came forward to speak during the public hearing, we'll close the public hearing and we'll move to discussion and consideration to act. So, were you wanting to speak for agenda item 5A or before I move forward? Is he wanting to speak for 5A or 5B? Okay. Okay, none? Okay. All right, and then we'll continue with our discussion, consideration to act. No discussion, is there a motion?
Yeah, I'll make a motion that we recommend to amend ordinance number 001-2021 Sweetgrass Plan Development, removing
Okay, did you record that? He did not have his microphone on. You okay? Why don't you restate it for the record, please?
There it goes. Maybe I pushed it away. I will recommend that, or move that we recommend to City Council that they amend ordinance number 001-2021 Sweetgrass Plan Development by removing including front yard maintenance of each home from the Homeowners Association required responsibility for maintenance.
Okay, there's a motion to recommend amending the ordinance. Is there a second?
I'll second it.
Motion been seconded. All in favor? Motion passes unanimously. Moving on, agenda item 5B. Hold a public hearing, discuss, consider, and act regarding an ordinance of the City of Haslett, Texas, amending ordinance 002-2020 Watercress Plan Development by removing the HOA shall also be responsible for the front lawn maintenance of the individual residential lots. And we'll begin again with our staff presentation.
Chairman and members of the commission, this is similar to the one we just heard, except the wording's a little bit different. And it says the HOA shall be responsible for the front yard maintenance of the individual residential lots. But it's basically the same thing. It's part of the plan development, which is a zoning issue, and it should be taken out of the zoning realm and put in the realm of between the homeowners and the HOA.
Okay, and again, is there anybody here representing the developer on the Watercress Plan Development?
I don't see one.
So before we move to public hearing, I want to just ask you a couple of clarifying questions for the benefit of the city residents that I think might help them understand before they offer comment on this. So the ordinance itself is the agreement on how development will occur between the city and the developer, correct?
That's correct.
It doesn't establish responsibilities of the homeowners obligations nor the developer's obligations. Those were all spelled out in the HOA document, correct?
That's correct.
And by removing the front lawn maintenance from the ordinance, it doesn't in any way strike it from the HOA document.
That would be correct. What the plan development does and should do is establish uses, setbacks, and those kind of rules, and not how it's maintained.
Okay. Thank you for answering those questions. And at this time, we'll open the public hearing. Is there anyone wishing to speak for or against agenda item 5B? And if you do, you're welcome to come forward. Please just turn on the microphone there and state your name and your address for the record.
There you go. Does that work for you? Perfect. My name is Jason Jacobs. My address is 2149 Clover Fern Way, Haslett, Texas, in the Watercress subdivision. I appreciate the presentation from the city. Thank you very much. Makes sense, the argument that you make. The push that I bring is we purchased these homes in Haslett and made an investment. So what we're asking under the city ordinance is to you hold the developers accountable for the maintenance of the neighborhood that we made an investment within. I appreciate that that's a contractual obligation made between the HOA and the homeowner at the time of purchase. That is relevant, cogent analysis. Appreciate it. But as a taxpayer in the city of Haslett, recognizing Haslett as the city I live in, I expect the city, right, to hold ordinances that hold developers who build subdivisions such as Sendera Ranch and leave. I ask you to hold them accountable to keep it nice and that my investment is protected. So the way I read the ordinance and the way that I see it is that it is the city protecting me, the taxpayer, from developers who pack up and leave and develop the next city, to make sure that Haslett stays what my family invested in and it continues to look as it does today. We could cite a number of neighborhoods that surround Haslett that don't have these such ordinances, that don't maintain their home values and don't maintain their yards. I'm not asking you to intervene on a daily basis, and as HOA participants, we can always lobby our HOA, I understand that, but I think it does help when our city government establishes an ordinance that protects my investment in my property and keeps it into which I invested. Okay, thank you.
Marcia Graber. My address is 2070 Clover Fern Way. I live in Watercress. I too echo the sentiments of this gentleman that just spoke so eloquently about his opinion about the homeowner value. I too bought into the Clover Fern Way home because I wanted to move into an area that was high value. I felt like this area was. I want to continue to see it grow, add value to my home. I want to invest my time in this community, maybe even serve in a capacity such as you guys. So I too want the city to hold the developers accountable. I am familiar with many developers in my line of business, and there are some that tend to be not as ethical as others. So please hold our developer accountable. I want to see this ordinance remain in place. Thank you.
Thank you, ma'am. Is there anyone else wishing to speak for or against? Okay, I do have a couple of comments that I'm going to read into the record because I think the applicants weren't here. Or actually, I have a couple of people who filled out comment cards. Mr. Jacobs, did you want to speak? Oh, that was you. Okay, I'm sorry. Thank you. Mr. George? Not going to speak? Okay. And then what about, and that's Mrs. Graber. Thank you. I already got your comments. And then these are additional comments from Ms. Chalupa. And let's see, her address is, it's Curtis and Debbie Chalupa. Address is 2014 Stargrass Road, Haslett. Kind of a lengthy comment here, so just bear with me because I do want to read into the record. The resident was not able to be here this evening. I spoke with you earlier, is this to Ms. Katrina? I spoke with you earlier today concerning ordinance number 002-2020, and unfortunately we cannot attend the meeting. We've been corresponding with the HOA since March 30, 2023, concerning YTL's substandard landscaping services. We gave YTL 2 opportunities to properly address our concerns before they finally telling them to not come on our property. It seemed as though the HOA was representing PYL and not us in the matter. So this summer I have been cutting the grass and applying weed control and fertilizer. We have asked the HOA to opt out of PYL service, and we're told that was not a possibility. We are paying for services that are not being rendered. YTL does not know how to provide services for a residential community. They put grooves in our grass due to using a riding lawnmower. They have also used a weed eater to cut the grass in our front lawn. We have seen them damage irrigation systems, and they did not apply weed control or fertilizer this spring as advertised, and most of the yards on our street were overrun with weeds. Please see attached pictures. We would like to opt out of front lawn care maintenance. If the majority of the residents wish to keep the status quo, at the very least, we would like an option to pick other landscape providers for lawn services. It's not about the money for us. We're just tired of the damaging our lawn, not getting the services that we're paying for in our HOA fees. We have also attached our correspondence with the HOA and asked them to come out and look at our neighborhood, which they never did. So I just wanted to read that into the record because it's provided for us. Okay, at this time we'll close, and nobody else wishes to speak at this time then? Okay, then we'll close the public hearing. We'll move to discussion and consideration to act.
Question, Maurice. The ordinance 002-2020. I'm sorry, I haven't read it. Maybe I should. Do you have a copy here?
I have it should be in your agenda, the copy of the section that we're modifying.
That's the plan development.
Yeah, where it says Exhibit B, C, General Regulations. If not, I got another copy.
Right, okay. That's what we're doing here. That's an amendment to the ordinance.
Correct.
That is correct.
What I'm saying is the ordinance itself. How does that read? Does that require?
Yeah, it's
Oh, here it is.
it's the part that's in red with the cross out, in the red line version.
And if you want to read it, I'll draw your attention over to the monitor on the side of the room.
One thing to note, as soon as all the lots are developed or built on, normally the developer is no longer part of the subdivision. And the HOA,
What now?
I said, whenever all the lots are built on,
yeah,
the developer of the lots is gone.
Right.
The only people that control out there would be the HOA, which should be the citizens that live in that subdivision. And if they don't like the rules, then they can actually change the rules for their HOA. Now, when it talks about the city maintaining, or not maintaining, but responsible, or the HOA is responsible, and the city's involved in it, well, the city's not going to go out there and maintain it, or actually require them to maintain it at the level that the HOA wants. they'll maintain it at a level that would be prescribed under city ordinances. And, not to, probably to the level of what, the HOA would.
which would not include weed control or the grass could grow to a
Yeah.
much higher standard, but the HOA would desire it. So the enforcement would look totally different from what the HOA would enforce.
That is correct.
Sure, yeah.
So yes, the declarations do give us an opportunity to both change management companies and influence the, okay. Correct. Yes, sir, it does. But can I respond to you in the gentleman's statement that when the developer leaves, the HOA is influenced by the people that live in the community? Terramount Management or whatever they're actually going to be the ones that maintain the HOA. And we pay them a fee as a part of those bylaws to continue to do that. So our influence is not simply by vote to change the bylaws. It is convincing a company that is running our HOA that we have no control of picking, that we want to continue the lawn maintenance or discontinue lawn maintenance. So that's why I say it's important that the city influence with the ordinance. I would even take it one step further, and I'll sit down. The city ordinance, I believe, is the only reason the developers offered the service in the first place. And they built that into their pricing and their advertising and what we paid to invest in those homes. So to change the ordinance, I believe materially changes the investment that we made in those communities, and it wouldn't have been a service available otherwise.
So okay. So in the ordinance, it clearly says the city will have no obligation for maintenance of any facilities. The
Yes, sir.
HOA shall be responsible for the front lawn. HOA.
Yeah.
Okay.
Yes, yes, sir. We're clear on that. And we're not asking the city of Hazlet to mow, but what we are asking you to do is continue to enforce an ordinance that requires both the HOA and the developer to continue maintenance under the guides that they initially sold the homes so that we can continue to pay for that service.
I don't think the HOA has any authority to it. I mean, the city to actually enforce an HOA
The city
to
never
administer
enforces,
its own declaration.
the city never enforces HOA regulations to do anything. What the city would enforce is if somebody's yard gets up to a foot tall in grass, then the city would come out and give them a citation, the individual property owner. And that, I'm sure that's not what you want. Is foot tall grass, but that's what the city can enforce,
Just like any law.
just like any law.
Just like any law, anywhere. You're saying the HOA board right now is a developer. I understand. Someday it's going to turn into a resident board.
Still managed by a management.
That you pick.
Maybe you can change it.
Okay.
I mean that can be changed.
Ashmore Farms just did.
Yeah.
Okay.
They did.
Yeah.
So yeah, a resident board can fire the manager. May take a long time before you become a board. I understand. I live in the meadow.
Okay.
So as it was built out, eventually the developer left and came board. Well, the developer was there. Any vote was basically 51% developer, 49% everybody else.
Sure.
Okay. So that can be done. Your declarations do address it. So those can be enforced. Your concern is, will they?
Correct.
Okay.
Or if it would have even been in the first, right? So I believe the service was only offered because the city ordinance required, right? So I understand the gentleman's concern that the city can't enforce it, but for the ordinance to have been on the books initially is why the service was offered to those communities that are being considered taken from.
But the sentence here, the HOA shall have the responsibility. I mean, in that ordinance, doesn't really mean anything because the city can't require the HOA to do anything.
but it absolutely is an ordinance they must contend to continue to build within your city.
Can't do it.
It's in your ordinance. So
I understand, but the city cannot come to the meadow and tell us how.
understand your
Other
ordinance may
than-
not have teeth, sir. I understand you may not be able to enforce it. That's not my argument. My argument is that the letter of the law exists, so it compels the developer to act. With no letter of the law, there is no teeth. That's irrelevant, the punishment. Whether you write them a ticket or you don't, what I'm saying is because the words exist,
Yeah.
because the ordinance is implied and passed by the city council, it compels the developer and the HOA to act on behalf of the ordinance. Whether or not you enforce it, it's up to you.
So let's take the ordinance itself.
Okay.
Section 7 that's up on the screen. I'm gonna pass through most of it here, and I'm gonna get to the second to last sentence.
Okay.
The city will have no obligation for maintenance of the facility,
Mhm.
okay?
Agreed.
The HOA shall be responsible for the front lawn maintenance of the individual residential lot. That doesn't mean that the city enforces that.
Agreed. And that's
Okay?
fine.
There is no enforcement element to that statement. That
Yes, sir.
statement is just saying that the HOA has made a decision that they're gonna take care of that. And how they put that into your HOA documents is not for the city to manage.
I agree with you completely.
And so because that's a self-managed item, it should not appear in this ordinance,
Understood.
because
And-
there's no enforcement behind it
And
at all.
my counterpoint would be that a law is not enforced because of the punitive damages for breaking the law. The law is the letter of the law, right? So the idea here, what I'm arguing is the spirit of what's in the exhibit is what provides homeowners the protection of having their yard. When you remove it, it doesn't compel them to act. I don't care if it's a $50 fine, a $2 fine, or a $2,000 fine if they don't obey you. I'm more worried about the action and the letter of the law that compels them to follow a city ordinance that you have the power to leave in. That's my,
All right, so I'm gonna take some questions, city
Sure.
staff, and then thank you for your comments. So is there any enforcement element to this that the city could administer?
No.
Thank you.
So again, Marie, how long has this ordinance? Since 2020?
That is correct.
That was passed. Was that all part of what? Yeah, all took things long.
That is correct.
So they,
Well, it was originally brought up in the Caraway
Yeah.
situation, and it's the same developer that did all three of these. Watercrest, Sweetwater, and Caraway. And the problems that a lot of the residents had were that the maintenance company that they were using was not doing a very good job. They were actually breaking off sprinkler heads, not fixing them, and things like that, and damaging their yards and not getting the treatments down the way they should. And so they really wanted to get with the HOA and make the changes to their bylaws, which they did. The developer, who is the same developer, made those changes, even though he had 51% or whatever it was in Caraway. They made the changes in the Caraway, and we anticipate him doing the same with the watercress and also the sweetgrass. No. He hasn't changed this one. He did Caraway because it has passed, taking it out.
so you're saying the developer has made that commitment to the city that they'll amend?
No,
Or-
he didn't make it to the city. He made it to the residents
Okay, to the rest.
He has
And
no
they-
obligation. to
yes.
the
No,
city.
that's what I'm asking.
and changed it so that the HOA is going to take care of the yards in Caraway, but not, the city's not going to be a part of it as part of their ordinance.
There, you're, there's an agreement that exists between the residents and the HOA. Then there's obligations between the developer and the city. At some point, that's gonna be a responsibility between the HOA and the city. You're talking about two different things. You've got an agreement between you and your HOA.
We're talking about number 7. You're saying the last sentence that cannot be enforced by the city. How can the city enforce the whole person? They can't enforce the last.
It's pretty easy to answer that because the perimeter fencing and the fencing around the wells is a city ordinance requirement, and they're just restating it in their ordinance. However, the HOA about the front yards is not a city ordinance. It is just written into this one particular, or these 3 particular plan developments. Yeah, like the drainage detention, if they don't do that, then people's yards flood and houses may flood. There's responsibility there. They have to keep it as per the engineering plan. In other words, they can't fill it up.
Okay. Any more discussion or variation act?
So, okay, I'm a little confused. So the developer initially put in their regulations, not back later. Is that correct?
Well, originally, the developer came in with this PD ordinance and said, this is what we want, and then it was just approved. It probably didn't have the scrutiny that it should have.
Yeah.
Could the,
Can I ask you a question again? So could you guys talk to the developer, or have they said, yes, we need that, that's the reason why we do this is because of this ordinance, or no, or?
So the first notification, at least that I won't speak for the entire room, but I received was that there was a notice from the city of Hazlet. So it's not something we had an opportunity, right? Where I find it troubling is that the developer was able to petition this committee on our behalf, homeowners. And the first notification we got was to come here and discuss it with you, right? So again, if I'm operating in good faith, which is what I've heard a lot of here, is that after this is resolved, he'll come back and he promised the right thing. The first action towards me as a homeowner was not, right? Because if he really wanted to discuss with me removing this ordinance in my best interest, he knows my HOA, he has 51%. He would have called said meeting and asked me these questions without even coming to this council. And you wouldn't have anyone in this room today, and you would have proved it quiet, correct? So my problem is I can't operate with faith if the gentleman has asked that something.
Yeah, let me clarify that just a little bit. The developer didn't petition us to do this. This is the city initiative.
So that can
He's not trying to get out of his responsibility to provide that service. This is addressing the fact that the city has no enforcement authority here.
And I appreciate that. I'm not asking you to enforce it, right? That's not the point. I get that. And in a civil litigation point anyway, I'd have to take him to court, right, to honor those obligations. That's not my problem. I guess where I'm confused then, sir, is that you said the initial question came out of the neighborhood of Caraway, and that they were unhappy with the services they were being provided, and he was going to undo this ordinance so that they could pick whomever they want.
No.
That's what I heard you say. If I misunderstood you, I apologize. Could you please re-explain that?
Yeah, there were residents from the Caraway
Hey, guys,
subdivision
got one
that were having problems with the HOA
Okay.
maintenance that they were getting from the yards, and they were
Sure.
complaining to us, and said, we can't do anything about it. That's really an HOA.
Okay.
Take it to your HOA board and get the rules changed so that they are being taken care of
Yes,
by
sir.
the HOA.
Okay.
And they have done that.
Okay.
And the city took it out of the ordinance,
helped
but
them.
it had nothing to do with the developer asking for it. It was city initiative.
100% appreciate that. And I would tell you that I'm glad you came to their aid, and I hope if we have a situation, you're able to do the same for Watercress. But what I would tell you is that Caraway is not Watercress. I don't believe we have those issues that they have, and I think a blanket change to a city ordinance based on someone else's poor experience is not reflective of mine, and I'm asking you to refrain from changing that.
No, I actually live in Caraway, and we went through exactly what you're going through about 3 months ago. And the people had the same reaction that you are having about 3 months ago. And we started looking into what we're paying landscaping, and we're paying $330,000 a year for something that should cost probably about $150,000. And so people started really looking into it now, and we just started. We're about 2 or 3 houses before we're complete with construction, and we're starting to have residents move in on the HOA board, and a lot of residents are attending the HOA meetings, and we've taken a lot more control from the developers. And there were a few people in the neighborhood who wanted to get rid of this because they didn't want to pay. Our HOA fees every year now are $1,840 a month to cover all the landscaping. Or, excuse me, a year. I'm sorry. Yeah, that would be, yeah, $1,840 a year and a lot of it covers just the landscaping. And a lot of people wanted to be able to do their own and save the money. But and I know the first reaction is you take this away, and now next thing you know, people are going to have yards that aren't taken care of. We have strong people that have joined the HOA board for the neighborhood, and they are probably stronger advocates than anybody you would get from a city. And so they've really taken ownership of it. And if the HOA, the developer tried to get out of that responsibility, they would meet very strong resistance. And I think like the point is that they're trying to make, and I understand where you're coming from. I had the same thing. I'm a disabled veteran. Having to mow the lawn kills my back for a day. And when they started talking about getting rid of this ordinance, my first reaction was, no way. And if you really look at the enforcement issue, the city has no play in it. They really don't have any role in the HOA taking care of our front yards. And so that's all, and I talked to the mayor at length about this when it came up for Caraway. And I know, like I said, I know where you're coming from. And after discussing it with him, it really changes nothing by taking it out of the city ordinance, because the city can't do anything about it based on what everybody's saying here. But I understand what you're saying. It's in the rules, so they have to follow it, but they really don't, because there's nobody to enforce it unless you want the same standard as Hazlitt Park. I don't want that in my front yard either. I understand. Yeah. Right, and the HOA agreements would, I think, hold the same weight. Yeah, yeah. Understood. Yeah. Mhm. Right.
I don't really worry about
Yeah.
it, but I will tell you that whatever your vote shall be, but as someone as a resident of Hazlet, right?
Mhm.
This community is raised my future. I ask you, gentlemen, right? It does nothing. You don't have to enforce it, but if it's no competency, but citizens are asking, then I no harm. It requires no budget. It requires no oversight, no cost by your own work. So that it have no impact on it.
But you just made a statement that convinced me we need that. You just said if you were to litigate and you took it to court, that you could require the city to, because that's what you just said. No, I'm just saying, the city could be required.
Well,
And so,
We,
what-
we, we,
so what?
all right,
Hold on.
so we did close the public hearing. If people want to come to the podium and speak, then you're welcome. I will go back to the public hearing, but I want you to come to the podium, state your name and address, speak, okay? I'm not gonna have a room full of back and forth like this. You're welcome to come forward and speak. So, ma'am.
Aaron Bourne at 2049 Clover Fern Way. First of all, I thought the meeting started at 7, so excuse us for being late. Didn't understand it was at 6:30. Okay, besides that, I feel the same way as this gentleman, Gene, who is part of the HOA, person I've spoken to several times on other things. We don't even get to be part of the HOA. Any of the rest, 75% of that name completed? I don't know. Whatever they consider 75%, because I'm not sure the number of homes, if it's 300, so, you know, over 200 and something been established, you need to consider that.
Thank you, ma'am. All right, anyone else wishing to speak?
And I'm in 10 Coburn Way, 2110, Clover Fern. I understand what's going on here. How many times there are so many homes? So based upon what's his name, the guy that comes out of the lawn, he says the problem is every time they have the lawn at a certain level, they go and they hit a hole, and then when they go up, they hit something and they break something. Legend scammed us all with a horrible ground beneath the grass. They gave us an awesome sod. Yes, that was perfect. It was healthy and everything. There's no reason for us to wait a whole year for it to look nice. It was already nice from the beginning, and all the yards look nice at the beginning. But with the lack of nutrients underneath, all the rocks underneath, and all the debris taken from underneath the rocks, and all the holes, our lawns are dying. And once you cut it short, like you're supposed to, at a certain length of the grass, you can see it all dead underneath. You can see all the rocks underneath. It's really bad. I mean, everybody's lawn really in our community needs to be redone front and backyard because it is not leveled. It is not leveled. My husband has fallen several times in the backyard because you could be walking outside, you just like go into a sinking hole or something. It's just like really bad. And I hope I kind of feel bad with YTL because they're getting a big brunt of it. I don't think we should remove it. I don't think they are the problem. I think it's American Legend that we need to go to and work with and have them fix what they should have fixed from the very beginning. All of us in the community pay large sums of money for our homes, and we should not have been given that mess, all the rocks and debris. I mean, I've heard of people in on our street, they've paid thousands of dollars already to feed the poor grass that was already healthy from the very beginning because no nutrients and all the rocks in it, because it just was not cleared. It was not leveled. The grass is dying. We're all gonna have ugly grass in a year, 2 years, unless we all pull all that grass out and go in there and do it ourselves because American Legend did not do it. That's my take.
Thank you, ma'am. Anyone else wishing to speak for or against agenda item 5B? Still nobody on the line? Nobody on the phone? Okay, I'm going to close the public hearing, and now I'm going to go back to discussion and consideration to act. Are there any other questions for the city staff?
So, I do. I want to know is if we left that on there, we leave the statement on here. Are we opening ourselves up to legal liability?
That's a lawyer question, and I really don't know, except it's just not a zoning issue.
I'm going to change your question. If we left it in there, is there any obligation for us to hold the HOA developer or the planned developer
No.
There's no enforcement.
There's no.
There's nothing in our ordinances that allow us to enforce
No.
this obligation.
The only city in Texas that enforced deed restrictions or HOA covenants is the city of Houston. Other than that, every other city in the state of Texas does not enforce deed restrictions.
We can enforce subdivision ordinances,
That's correct.
but that doesn't address
It doesn't
an
address
HOA
this.
covenant
No.
of long-term.
Yes.
Thank you.
So if we left that in, that be the only subdivision in the city that has that sort of safety?
Yes.
So Laterra
doesn't have it.
care. We just took care of.
Sweetwater
Sweetgrass.
does now until the city council acts
Well,
on it.
we just handled Sweetgrass at the city council,
That's correct.
and then here. So I know Meadow doesn't have
No other place has it.
nobody else.
So going back to the time of this plan development, I don't think you were here when this was actually adopted, but my recollection is there was a lot of things that were being discussed back and forth within the city. The city was requesting design element changes. The applicant was conforming and suggesting alternate to things that were being requested. Is this very likely a statement saying, I am going to make sure we do this for the HOA, for the home? Rather than creating an obligation to the city, it's more a declaration statement that the developer is saying, I'm going to be doing this. Is that most likely what this is?
I would say yes.
Well, I have one question. It doesn't incur the city any obligation. It doesn't do the city any harm.
It doesn't harm the city that I know of in any way. It's just not, like I say, a zoning issue.
Okay, is there a motion?
Yeah, I'm gonna make a motion. I'm gonna recommend that motion to recommend to city council that we amend ordinance 002/2020 for Watercress by removing the HOAs to be responsible for the front lawn maintenance of the individual.
Okay, motion was made to recommend amending the ordinance. Is there a second? I'll second it. Motion goes to a vote. All in favor? All opposed? All right, it's a tie. So in that case, does the alternate vote, Katrina, make? Yeah, because the ordinance or the motion does not pass. That's the only path forward. Okay, is there an alternate motion?
So I'll say it right, correct me. I'd like to make a motion that we defer this for a month and research this. I just want to know if there's any legal obligation. I don't want to.
Okay, I don't know that we need a motion.
I just want to, can we just table it just to get, I don't want to leave something on there that's going to put us in legal liability by the same token.
Okay, we'll take that as a motion. Is there a second? Motion made to table. Is there a second? There's no second, so that doesn't go forward. Okay. So you did second that? Okay. All
I'll
right.
second that.
It's also the only subdivision that doesn't have control of their own HOA yet. And that's for me what throws it over.
I just, like I said, if it's not going to harm them, I'm just concerned by that's my.
Right. That's also not a occupied subdivision yet. Sweetgrass is not occupied.
Okay, we're in discussion, so it's got to be relevant to the motion, otherwise the discussion can't continue. We're talking about Northland. You got to talk about the motion, the table.
At this point, I'm not aware of any other subdivisions that have.
Okay, there's a motion on the table that's been seconded. All in favor of the table? All right, motion passes. Okay, so we'll table that. We'll bring it back up next month. Okay, nothing needed in executive session this evening. Nothing on agenda item 7. We've got the status of current development projects and future agenda items. Anything that we need to be aware of as we go forward? Let's give the audience an opportunity to walk out before we continue discussion. Those who want to. All right, thank you. All right. If y'all could, we still have other topics, so if you guys could step on out or take your seats, that would be great. Okay, so we're on to agenda item 9, future agenda items. Is there anything in particular that we need to be aware of as we go forward to next month? 5 what?
5B will
Yeah,
be back.
5B.
And we'll get some kind of legal determination on that for you. There are things that are in the works right now, but I really can't tell you what they are. But I anticipate that over the next few months, you'll have some very interesting items.
Anything that you know is going to hit our agenda for next month?
There is a site plan that came in that's on the south corner of Schoolhouse Road, where Schoolhouse Road hits 156.
Yep.
On the west side, little extension of the shopping center. It's another building. They should be here next.
Okay. All right, good. Well, before the meeting started, Morris and I were talking about workshop topics, reviewing ordinances for updating based on current conditions, development that's occurring and everything. So you're going to take a look at areas that might be relevant for us to review.
Yeah, what I'll do is I'm going to circle some areas in an ordinance I think need some work.
Okay, and if there's one that you want to bring starting next month, feel free to put that on the agenda. We'll commit to say 45 minutes at most of the workshop, plus whatever else we got.
Okay. You want to start the workshop earlier?
Let's take care of our normal agenda item.
Then make it afterwards?
Agenda item 5, and then let's follow by the workshop.
Okay.
That way the applicants aren't waiting around for us. Yep. Okay. Anything else? No? We're adjourned. The time is... What is the time? 7:18 p.m. What?
This conference is no longer being recorded.